Well, we've come to this point. We are going to talk about the NextGen Bar Exam or the NextGen UBE, a whole brand new format that we will see starting July 2026 in select jurisdictions. They'll start rolling out over a couple of years until 2028. If you are one of the lucky ones who are going to take this next generation method of torture, I guess we should take a look at some of the release questions, because the NCBE has been so kind to let us know what's in store for us. So I thought I would just kind of go over briefly what the NextGen UBE is, what sections there are, and go over some multiple choice questions, our favorite, multiple guess. So just very briefly, the multiple choice questions, or the MCQs, they're no longer called the multi-state bar exam. It's not an MBE, it's MCQ. Use proper terminology. About 40% of the allotted time, so there's going to be 3 sessions where each session has MCQs, IQSs, integrated question sets, and performance tasks, which are similar to PTs. About 40% of that time will be spent on the MCQs, but 49%, almost half of your score, is going to be allocated to the MCQs. So it is more concentrated than your other sections. But today I just want to go over these 8 questions and see how we can start to think about these questions. Right off the bat, there are some overlaps and there are some differences between these new MCQs and the legacy or the classic MBE style questions. For example, if we take a look at question number 1, you're going to see phrasing like you are a lawyer representing a client, select 2 instead of 1. So there are some minor differences, but at its core, the way to approach them is still similar. Like, you don't have to overthink the fact that you're a criminal defense lawyer. It just tells you that, oh, maybe this is a criminal law, criminal procedure question. And in fact, if you start looking down here, it just pops out at you right away that this is a crim pro question, because these are exceptions to warrants. And we're talking about the 4th Amendment. It's definitely crim pro. So let's kind of go over this question and see how we would approach this step by step. It helps to kind of go through this general framework. First, to just take a broad look at the question. I don't think there's any set rule about where to start first. You could start with the call of the question. You could start with the beginning sentence right away if you want to. But for convenience, maybe if you just want to have a systematic approach, you would just start with the call of the question. I think that's probably safer. But for example, some other questions you can kind of see right away. Let's see. Yeah, like you can see right away here, it might be a real property question. You can kind of tell using this the choices as well. But let's go through that procedure first. So take a broad view, take a look at the call, take a look at the answer choices. Fortunately for this one, right away, just based on these 6 choices, that this is a crim pro question. So that's step 0. And then step 1 is think about any thresholds. First things you want to think about, threshold issues. And then number 2, think about the core doctrine. What is this question trying to test you on? And then number 3, apply the rule, especially in cases like this where you have to select 2. And this is the same where you have to select 1 out of 4 answer choices. Think about how to eliminate distractors or the wrong choices. Okay, so we identified the topic, crim pro. Threshold issues. So crim pro is actually it's like a subset of constitutional law, because it tests 4th Amendment, 5th Amendment, 6th Amendment, and to some extent 8th Amendment. In constitutional type of questions, you want to think about any threshold issues. One of the most common ones is standing. With that in mind, the threshold issue is possibly standing, and then we don't know what the other choices, whether they will be relevant. One of them will be, because we're going to select 2. Let's take a look. So you are a criminal defense lawyer representing a client. So you don't have to think about this too much. This is just kind of giving you background context. The police found fentanyl in the guest bedroom of your client's uncle's house when responding to a noise complaint. When the uncle answered the door, the officers asked if they could look inside the house, and the uncle agreed. If you're sort of familiar with crim pro, this is third-party consent searching. The client did not live in the house. He was not there. He or she was not there at the time of the search. And your client was in the guest bedroom 2 nights prior to the search. The uncle told the officers that your client was the last person to have slept in that room. And now you want to try to suppress the fentanyl as evidence under the Fourth Amendment. So this is like a search type of issue. And now, which of these topics are going to be the most important to research to determine the likelihood? So these are just like, this is just words. You don't have to think about what it means. Basically, what's the most relevant thing to think about here? The threshold issue, again, constitutional issues, you should immediately ask whether there is standing, whether the defendant even has standing in the first place. Constitutional rights are personal, so a defendant can't challenge government conduct unless their own rights were affected. And in this case, I think this is a pretty top candidate for an answer. So the step 2 I was talking about, that was what's the core doctrine? So if standing is relevant, then we need to think about whether there is a reasonable expectation of privacy under the Fourth Amendment. So the house belongs to the uncle. Let's see, the uncle's house. House belongs to uncle, not your client, not the defendant. And also, your client was not even present during the search. But the Fourth Amendment requires a personal expectation of privacy that could be subjective, objective. The first question is whether the defendant can even challenge the search at all. So I think we should keep option F and take a look at these other ones. So you'll notice right away, or maybe not right away, but these first 3 options are exceptions to warrants, and these 2 answer choices are standards for search. I think what we might be interested, because the officers asked if they could look around inside the house, and the uncle agreed. There's no mention of a warrant, but you need a warrant. And yes, you do need probable cause and specific information to get a warrant. But I think the core doctrine here is consent search, because it's a major exception to the warrant requirement, right? If someone has control over the premises, like the uncle, consents to a search, the police generally don't need a warrant. Let's see if we can find something about that here. Consent search. One with authority offers voluntary consent to the search. So in this case, the uncle just said, hey, come on in, take a look. This directly triggers the consent search because the uncle controlled his home. His consent, his voluntary consent, can authorize the search depending on whether the consent was valid. It seems valid, but that's not really the issue. It's whether it is an issue in the first place. So essentially, we're just issue spotting in this question. Let's take a look at the other ones. Exigent circumstances, I don't think that's it. Hot pursuit, nope. Probable cause and reasonable suspicion. So again, probable cause is a factor for obtaining a valid warrant. However, valid consent, if there was valid consent, that would eliminate the need for a warrant supported by probable cause. And of course, because I have the benefit of hindsight, we can check the answer. The correct answers are indeed standing and consent search. So you will get partial credit if you get one of these correct. So if you got consent search, you will get 1 point. If you get standing, you get another point. So congratulations for solving this. We're going to take a swig of wine because what is the bar if there's no alcohol, right? So this is the Stoltman unfiltered white wine. This is pretty hard to find, but I found it at this wine store in LA. You cannot find this at Whole Foods. Although my favorite Stoltman wine is a rosé, which you can find in Whole Foods. So if you're into wine, take a look. Now, let's go on to question number 2. We're going to make it a little bit more challenging since we're getting a little tipsy. All right, so step 0, what is this question about? We see some numbers. We see, looks like we are doing a contracts question. According to satisfaction, consideration. These are all contracts terms. So we know right away that we have to be in contracts mode. And what's step number 1? What's the threshold issue? For contracts, of course, there's the classic UCC versus common law. But in this case, what is the nature of the dispute? I think we have to take a look at the facts here to kind of tell. So your client owns a carpet cleaning company. The company recently contracted with a customer to clean the carpets throughout a building for $15K. The customer sent your client a check for $12, along with a note saying that some of the carpets still had stains and blah, blah, blah. The customer's note also said that if your client cashes the check, the remainder of the debt will be discharged. Wow, this guy's pretty needy. But now your client wants your advice as to whether the company can cash the check without relinquishing its right to recover the remainder of the customer's debt. So this is another issue spotting type of question. Like, which of these search terms or issues would be most likely to produce resources that will answer the client's question? So if you're doing some research, like what terms are you going to look for? What is the issue here? We have some partial payment here. The nature of the dispute is whether partial payment can satisfy an existing debt. So this is a sort of straightforward. Like what does that match up to? It's not consideration, it's not novation, it's not offer and acceptance. I think we go straight to accord and satisfaction. If the creditor, in this case, the client, cashes the check under circumstances showing that there is agreement to this new settlement, then your client can be treated as having accepted the accord and satisfaction. And checking the answer to question number 2, correct answer is A. We're 2 for 2. How about that? Now let's move on to question number 3. Let's see what kind of question this is. So we have a defendant. Oh, look here, best evidence. So we already know that this is an evidence question. I mean, it says evidence right here. So this is about best evidence, hearsay possibly. So that's step 0. We got an evidence question. Let's take a look at the facts. Defendant is being prosecuted for conspiracy to possess meth with intent to distribute. The government wants to have one of its agents testify to a conversation that he overheard between the defendant and a co-conspirator regarding some shipment of the meth. So that conversation was also audio taped, although critical portions of it are not audible. The defendant objects to the testimony of the agent on the ground that it is not the best evidence of the conversation. So, is the testimony of the agent admissible? This is about the best evidence rule, so you have to know what the best evidence rule is and how it works. The best evidence rule, it requires the original writing, recording, photograph, etc. when someone's trying to prove the contents of that item. But this rule only applies when the party is trying to prove the content of the writing or the recording itself. To prove the content of a writing, the original must be introduced if available, and it applies where the content to be proven depends on that very document. So it's got to be the original to reduce error, and the original is not required if that original is lost, the opponent cannot produce it, or if there is some personal knowledge. So based on all of this, what do you think the answer is? Is the testimony of the agent admissible? Do you even care about whether it's the best evidence? Because the agent is describing what he heard rather than trying to prove what the recording says, and also the critical portions are not even audible, the best evidence rule does not require the tape to be introduced. So the testimony itself is admissible without the recording that also happened to have been recorded. So let's see. Yes, it is admissible because the best evidence rule does not require proof of the conversation through the audio tape. Or yes, because the audio tape is partly inaudible. I think it's got to be one of these, right? Because the testimony should be admissible. Let's take a look at the other ones. The testimony is not admissible, this answer choice says, because the testimony is not the best evidence of the conversation. That doesn't really hit on what the best evidence rule is about. That's about whether the evidence that's sought to be introduced is the original. I don't think that's really the issue here. Or how about choice B? The testimony is not admissible because that testimony recounts hearsay, not within any exception. Okay, so testimony can be hearsay in certain circumstances, but there's no hearsay issue really because it's not trying to prove an out-of-court statement. It's about what the agent heard. So it's personal testimony, personal knowledge. Hearsay is not really the core issue here. So it's got to be C or D, and I think it is closer to C because we're trying to introduce testimony here as personal knowledge. Whether the audio tape was audible or not is kind of irrelevant. So the answer choice has to be C. The best evidence rule doesn't require proof of the conversation through the audio tape. We just need the agent to kind of talk about what he heard. And when we check the answer, the correct answer is indeed C. Great job. Talking to myself here. And by the way, this question is very similar to a classic MBE question. The question is not talking about whether you have a client, you're representing someone. This is a straightforward, a defendant is being prosecuted. Is the testimony of the agent admissible? So there, again, there's some overlap between the prior classic legacy exam and this new format. And they will mix up the format, but you just have to remember the core. What are they testing you on? What is the issue? What is the rule? How do you apply the rule to the fact? And that's it. So the same approach applies. Sometimes you just need to apply it twice out of 6 choices, or you have to deal with different interesting ways of wording the question, like what search terms do you need? That's a very kind of modern thing to do. But sometimes you get classic ones like this, so just keep that in mind. And let's move on to question number 4. So what kind of question is this? What's the subject? So we have a client, a bank, a mortgage. We can actually kind of see right away just from the answer choices that this is a real property question. Talks about title, talks about deficiency statutes, recording statutes, statute of frauds. That's kind of like a contracts topic, but we do see there's like foreclosure, mortgage. So this is a real property mode of thinking. So it potentially helps us eliminate this choice as well. So let's take a look at the facts. Your client, a bank, purchased a mortgage and a promissory note from a credit union that had lent a borrower money to help finance the purchase of a home. The borrower stopped making payments on that obligation, and the client, the bank, has initiated a foreclosure action. Another lender has now come forward claiming that they have a prior mortgage on the same land and should be paid before your client, the bank, from any money collected via foreclosure. Which of the following legal topics, another issue identification type question, is the most likely to affect whether the client, the bank, can collect what is owed on its mortgage and promissory note before the other lender? So this is screaming priority. It's talking about prior mortgage. There's another party. It's talking about before the other lender. So this is very clearly like a straightforward who has priority. Out of these answer choices, we can strike out D already because there's no writing mentioned here. So out of these 3, which one do you think has the most relation to priority? It's not deficiency statutes. Deficiency statutes it's about whether a lender can recover the remaining balance of a loan after foreclosure. So it is related to foreclosures, but it's not related to priority. Covenants of title, that's also not related to priority because it concerns promises made by a seller in a deed about the quality of the title, habitability, things like that. It's pretty clearly recording statutes. Recording statutes, they determine priority between competing interests. So we have multiple interests in real property. There's like race notice types of recording statutes. They're not relevant here, but these statutes protect parties who properly record their interest and who gets to acquire the interest with or without notice of earlier claims. So let's check. It is C. We are correct once again. We are 4 for 4. I'm going to take another swig and move on to the next question. All right, question 5. What is this question about? Summary judgment. Okay, so we have civil procedure right off the bat. So what is summary judgment? Procedurally, that happens before trial. Let's pull up the definition here. Summary judgment shall be granted if, from the pleadings, affidavits, and discovery materials on file, viewed in light most favorable to the non-moving party, the moving party shows that no genuine dispute of material fact exists, and the moving party is entitled to judgment as a matter of law. So let's take a look at the facts now that we know what summary judgment is about. A construction worker sued an insulation manufacturer in federal court, claiming that he had developed a chronic health condition as a result of 20 years of exposure to the manufacturer's insulation at the work sites. The manufacturer answered, denying all liability and saying that it had never supplied insulation to the worker's employer. The worker's attorney deposed the manufacturer's president, and the manufacturer's attorney deposed the worker. Immediately after that, the manufacturer moved for summary judgment on the ground that the worker had no evidence showing that the insulation had ever been used by the worker's employer. So now, what should the worker's response be in response to the motion for summary judgment? So these answer choices are pretty long, so let's just go through them one at a time. So one choice, we could argue, or the worker could argue that more time is needed for additional discovery to show the manufacturer's liability and attach a declaration describing the desired discovery. Option B, argue that the motion should be denied because a central issue in the case will be the manufacturer's credibility on the question of its distribution of the installation, and only a jury can decide questions of credibility. Option C is to argue that the motion should be denied because the manufacturer failed to attach any evidence to his motion to show that the installation was not used by the worker's employer. And option D, make a cross motion for summary judgment, arguing that the manufacturer has introduced no evidence to show that its installation did not harm the worker. So I think we can get rid of some distractors off the bat. Summary judgment is not about credibility. So option B is talking about credibility and jury question, a question of jury, and whether a jury can decide such questions. I don't think this is the best answer. Option D talks about a cross motion for summary judgment. So it sounds like the worker is filing a motion, its own motion for summary judgment, but that's not how summary judgment works. So if you remember the rule here, the moving party, in this case, the manufacturer has to show that there's no genuine dispute in material facts. So the burden is on the moving party. The non-moving party doesn't have to do anything to try to prove anything. So choice D is not the answer here. So we're kind of tied between choice A and choice C. And actually I had to look up this rule. Summary judgment is governed by FRCP 56. And in subsection D, there is a rule that says the court can allow time to obtain affidavits or declarations to take discovery. So under Federal Law 56D, a party opposing the other party's summary judgment can explain that additional discovery is needed to respond to the motion. So if the court agrees, they could delay ruling on the motion so the party can gather more evidence needed to oppose summary judgment. The closest to that here is option A, argue that more time is needed for additional discovery. Attach a declaration describing the desired discovery. This is interesting because in the classic MBE, we didn't really see, or at least I didn't really see any questions or issues that have to do with getting more time to respond to a summary judgment. Maybe the NextGen MCQs are kind of testing more nuances. I know the MBE has expanded on that as well, but it's become more important to know some of these smaller rules. It's not necessarily a terrible thing because everyone else is not going to know it either. So possibly this is going to create more of a curve. Let's take a look at option C just to see if we missed anything. Argue that the motion should be denied because the manufacturer failed to attach any evidence to his motion. But when discovery is not complete, the correct procedural move is to invoke Rule 56D to get additional time to perform discovery, to obtain the necessary evidence, rather than attempting to argue the merits without that additional evidence. Option C doesn't really consider the possibility of asking for more time. And if a party really doesn't have any evidence after discovery is complete, summary judgment may be appropriate, but we're not at that stage yet. Option C could, in some situations, be a good answer, but we still have the option of asking for more time, which is in option A. So if option A was not part of the list of options, then maybe option C could be the best answer. If a party truly really has no evidence after the discovery is complete, then yeah, summary judgment may be appropriate, but maybe discovery is incomplete, in which case the correct procedural move would be to invoke Rule 56D and argue that more time is needed for additional discovery. So A is the best answer. All right, moving on to question 6. We are more than halfway done. For that, we'll congratulate ourselves again. And by this point, you probably know what this question is about. Just looking at the answer choices, we can tell that this is a real property question. It's talking about adverse possession, conversion, blah, blah, blah. Negligence is a torts thing, so I'm going to assume this is maybe our distractor. We're going to have to eliminate it probably. And this is another issue identification type question. which of the following legal topics are the most important for you, for me, for everyone to research before advising the client. So once again, we are representing a client. Again, this doesn't really turn into like a different format. I mean, the wording is different, but ultimately, we just want to figure out what this question is about. Speaking of these issue identification type questions, we don't even have to apply the rule. We don't have to know the rule. We just have to know the issue. I have always said that knowing the law is not just about knowing the rules. It's also about knowing the issues. So the NextGen MCQs are going to require you to know the issues, not just memorize a bunch of words and rules that you don't even know where to put. Now you're going to have to know how to even bring up the issues, how to identify the issues. So make sure we can do that. Taking a look at the facts, your client owns a home with several acres of surrounding land. Recently, your client noticed that his neighbor built a fence that extends onto your client's land. The client is not sure when the fence was built because that part of the client's land was obscured by large trees. When the client contacted his neighbor about the fence, the neighbor claimed that she did not know the location of the property line. The client has shown you a recent survey of the property that confirms the encroachment and has asked us, whether he has a claim against the neighbor. So what legal topics are going to be most important? What is the issue here, in other words? So here there's some element of physical encroachment. There's a fence that extends onto your client's land. So we want to know what involves physical encroachment. So at first glance, maybe trespass could be something like that, because that requires some physical entry onto your land. Conversion, adverse possession, maybe. That involves occupation onto the true owner's land. Conversion, maybe that too, because there's a fence that extends onto your client's land. So there is some occupation of your client's land. Implied easement, no, that has more to do with permitting someone else to do something. Same with license. Negligence, I think that's distractor. That's irrelevant here. So we're left with trespass. I think that's one of the answers that we will be credited for. So adverse possession or conversion. At first glance, conversion sounds like something has been taken from you. Control has been taken from you. But conversion, remember, has to deal with personal property. It's not about real property. So, and because this dispute involves land rather than movable goods or personal property, this is not the relevant doctrine. So our final answer is going to be trespass and adverse possession. And lo and behold, the correct answers are adverse possession and trespass. If you got trespass, you'll get partial credit. If you got adverse possession only, you'll also get partial credit. Let's now move on to question number 7. So what is this question about? Let's look at since the answers are short, we can just kind of take a quick look. Employment at will, parole evidence. So it's kind of a mix of topics. Takings is, con law, property. There's a con law, there's a contracts, con law, contracts. I'm not sure what this is actually. Contracts, maybe. So since we can't tell, so we don't, first of all, when we try to answer a question, time is of the essence. Don't get stuck on anything. Just keep moving forward. If you get stuck on it, you're going to waste time that you're allotted. You're going to waste precious seconds. So if you feel yourself getting stuck, don't try to figure it out and spend all that time. Just keep moving. So our client, State College, hired a tennis coach at a salary of $60K per year. The parties orally agreed on a start date but did not discuss a contract duration. 7 months after the coach started, the college, now wants to fire the coach without holding a hearing because of budget cuts to the college's athletic department. The college, has asked us for advice about the potential legal repercussions of firing the coach. So what are the issues here? So we see a couple of phrases here. Without holding a hearing, that sounds like due process, specifically procedural due process. It talks about an employment contract. Let's see. Yeah, firing and hiring. So just right off the bat, we are seeing procedural due process possibly being a relevant topic. Performance is not really talking about performance. The coach there's no indication that the coach failed to perform his duties. This talks about due process, but this is about substantive due process, which involves personal rights. So employment is not a protected right, like race or gender, some of the classic ones. There's no takings issue here. Parole evidence, yes, there was an oral contract. So let's keep this one in the back of our minds. So we have choices A, B, and C. So we are not going to be considering these. Let's take a look at what procedural due process is about. It protects against intentional deprivation of life, liberty, or property without due process of law. So of these three entitlements, I think property could be a right that's being encroached upon. In the case of our client, it's a state college, so it is a public employer, and the coach is a public employee. So there could be a property interest that's being violated if the firing happens without holding a hearing. Thinking back to question 1, with every constitutional type question, you had to check for standing. Another thing that you want to check for with constitutional type questions is whether there was state action. Without state action, constitutional law probably won't apply. So here there was state action. There was a state college doing the hiring and the firing. So most likely, procedural due process is going to be one of the answers. Now, between A and B, parole evidence is interesting just because there was an oral agreement. But remember that parole evidence is relevant if there is a written contract. There's no written contract anywhere. There's no final expression of the agreement. In fact, there was not even a discussion of a duration. So I think we can get rid of B. And employment at will is not really a commonly mentioned issue on the bar exam. But I think in this case, this is about employment, and this is about employment at will. Maybe they're planning on testing employment law at some point. Who knows? The answer to question 7 is A and C. Employment at will and procedural due process. Now we're at the final question. Question 8. Should we take a swig before we move on? This is kind of got a couple of sips left here. I'll save the remaining after we finish question 8. But yeah, let's take a look. What is this one about? This is clearly a real property question. We're talking about landlords. We're talking about tenants. We're talking about suing for possession. So right off the bat, we know it's real property. Let's see what this landlord-tenant dispute is about. A landlord and tenant orally agreed to a commercial tenancy for a term of 6 months beginning on July 1st. Rent was to be paid by the first day of each month, and the tenant paid the first month's rent at the time of the agreement. When the tenant arrived at the leased premises on July 1st, when the term began, the tenant learned that the previous tenant had not vacated the premises at the end of her lease term on May 31st and did not intend to vacate. The tenant then sued the previous tenant for possession successfully. The tenant did not inform the landlord of the eviction action until after the tenant received possession. The tenant then sued the landlord, claiming damages for that portion of the lease period during which the tenant was not in possession. If the court finds for the landlord, what will be the most likely explanation? Select 1. So we are assuming right off the bat that the landlord has won this suit against the tenant. So there's got to be some basis for the landlord to win this action against the tenant. Let's take a look at the choices here. By suing the previous tenant for possession, the tenant elected that remedy in lieu of a suit against the landlord. The landlord had delivered the legal right of possession to the tenant. The tenant failed to timely vacate as required to sue for constructive eviction. The tenant had not notified the landlord before bringing the eviction action. Of these choices, there's a couple that I don't think are legal standards that apply. So there's no rule for notifying the landlord before bringing the eviction action against a previous tenant. So I don't think D is the right choice. The tenant failed to timely vacate to sue for constructive eviction. So constructive evictions are typically done by the landlord. It's not really something that the tenant does. So this is irrelevant because constructive eviction is not what the tenant did here. He actually sue the previous tenant. Constructive eviction is about rendering the property uninhabitable, and that's not what happened here. So C is not the right answer. Choice A, by suing the previous tenant for possession, the tenant elected that remedy in lieu of a suit against the landlord. So the tenant could do self-help. The tenant could terminate the lease, abate the rent, seek damages, but there's no waiver of other suits that the tenant could do. I'm not really sure about this one. Choice B, the landlord had delivered the legal right of possession to the tenant. So one of the duties of a landlord is to deliver actual possession of premises at the beginning of the lease term, and it is a breach of this duty if the holdover tenant has not been evicted. So looking at this, it looks like the landlord may have breached his duty to deliver actual possession. There was no actual possession because the previous tenant was still continuing to stay there and intended to stay there even after the new lease term started on July 1st. So at first glance, it doesn't seem like B is the right answer. But we have to assume that the court found for the landlord for whatever reason. We don't know the exact mechanism that the court found for the landlord, but what's the most likely explanation? If we had to assume that whatever happened, the landlord won for some reason, maybe there was some other additional fact that says that possession of premises has been delivered to the tenant. Maybe the transfer of the legal right to possess, that still satisfied the obligation to deliver possession. C and D are out. A is, there's no self-help concept that says that if you do self-help, that you give up other remedies. There's no concept that says you are electing that particular self-help method. You're not giving up other ways to recover damages. So out of these choices, B is the least worst option here. And when we check this with the benefit of hindsight for me, the correct answer is B. This was a tricky one. I think that in this case, we have to eliminate the worst choices. C and D are not it. A is, there's no concept that says that if you pick one self-help method, the other ones are barred. So we're only left with B. And this exemplifies the need to know the nuances. And in this case, that's also tricky because if you know the nuances, you know that delivery of actual possession is a duty. And if you're thinking about that, then you want to eliminate choice B, but then you're left with no good option. So if we have to choose between A and B, this is talking about the legal right of possession. There may be, in certain jurisdictions, the legal right of possession may be sufficient to meet the duty as a landlord. So B is the best choice, and sometimes you just have to pick the best choice, not necessarily 100% correct choice, but the best available choice. So I hope that gave you a decent idea of what these new MCQs will look like. I would encourage you to maybe go over these questions on your own again and see if you can go through the same process of identifying the subject, seeing what the relevant legal issues are. Sometimes you don't even have to solve the issue, you just have to kind of identify it. So that makes certain questions simpler. And these questions, they make up, again, almost half of your score. So it's important for you to get these down and be comfortable with these different types of language that you see. For example, you're a criminal defense lawyer, which legal topics are most important to research? So if you're identifying issues, you may not have to apply the rule. If you have to apply the rule, then you have to know the rule, of course. And in some cases, you have to know the rule so well, the nuances of the rule, which is same as usual for the classic MBE as well. But the core of this type of question is similar to the legacy MBE. So if you're looking for questions to practice on, the NCBE does offer study aids besides these sample questions for purchase, but it's possible that you can still benefit from the usual sources of MBE questions because there are questions that are similar to the classic MBE questions. This would be one example of it. It has the no, yes answer choices. There's no pretending to be a lawyer. for a client, but it will be good to become familiar with these different formats. And don't forget about the other sections of the NextGen UBE. There's integrated question sets, which are less objective. There's more short answers. And performance tasks, you may be already familiar with them because of the performance tests, the PTs, the MPTs. I will link to information that the NCBE has put out, including scoring, how the sections are divided into segments and sessions. So you can take a look at this. Maybe this page would be useful, as well as this one, exam structure and timing, how many questions there are per session, how long they take, and then compare it to the scoring that they tell you about. Your point allocation, 49%. Compare that to less than half of this 3-hour section. So take a look, because knowing the rules of the game is the first step to mastering the game. But ultimately, these MCQs are going to be hugely important, taking up half of your scores. So I would encourage you to get familiar with it. I don't think there's too much to panic about. You just have to get adjusted to the language. And as usual, just know the issues and the rules. Cheers.